Broadcasting. Good afternoon, and thank you for joining us today for this live stream webinar on the first day of Level 2. Although today marks a huge milestone, it is merely another step along the long and winding path that we business owners must navigate. Nonetheless, I hope that you can all take a moment in your own way to celebrate this milestone. No doubt you've learned a lot about yourself, your business, and the people within your business during levels 3 and 4. The move to level 2 will of course bring its own challenges and opportunities for business owners. Just like we have had over the last couple of months, my team and I are here again today to discuss some of these challenges with a view to help you survive or thrive, or consider other options if your business may no longer be viable. If you're joining us today for the first time, my name is McDonald and I'm the host for today's panel discussion. I'm one of the business owners of Godfreys Law. I have 20 years experience in both commercial and employment law matters. Today, our team is going to speak about what to do if your staff are refusing to come back to work after the shutdown, ways that businesses can manage their debtors to keep cash flow healthy, and the process of liquidating your business if it comes to that. I hope you'll find something of value here today and keep a lookout at the end of today's webinar for how to get in contact with the panellists from today's team. So today I'm joined by 3 very experienced panellists, and I'm going to get each of them to briefly introduce themselves. So first of all, today we'd like to warmly welcome a new panellist, and we're lucky to be joined today by Lynda Smart, who's a chartered accountant and insolvency practitioner from Rodgers Reidy. So welcome, Lynda.
Thanks, Brett. It's lovely to be here.
Awesome.
So as Brett said, I'm an insolvency practitioner. I'm a director with the firm Rodgers Reidy. I'm a qualified chartered accountant and also an accredited insolvency practitioner with Recovery, Insolvency and Turnaround Association of New Zealand. So I'll be able to share some thoughts with you today on the liquidation process.
Fantastic. Thank you, Lynda, and welcome. Rightio, next up we'll introduce an old face, no disrespect, Andy, welcome.
Thanks, Brad. I'm glad that the no disrespect was added in there. After being in lockdown, I feel like an old face too. For those that may not know me or of me, Andy Ogilvie. I'm an associate here at Godfreys. My areas of practice are primarily employment law and civil and minor common law matters. I have a fairly substantial practice in insolvency matters and dodging insolvency matters, and also in tax debt negotiation to avoid insolvency matters, and I'll be working with Lynda on today's segment on insolvency. Thanks, Brad.
Great, thank you, Andy. Rightio, and last but not least, we'll hand over to James Hobcraft, who had the lucky or unlucky distinction of joining Godfrey's Law shortly before the lockdown came into effect. So, James, welcome.
Hello everybody, and welcome back to our regular viewers. For those who don't know me, I, as Brad has mentioned, recently joined the team as a solicitor. I've 20 years of business experience. I've had some good times and some tough times, so I do understand what some of you may be going through at present, and that sets me well with the legal training to give you useful and practical advice on how to overcome problems, both in employment arena and commercial law matters. Thanks.
Thank you, James. Rightio. So before we get in to the discussion today and hearing from our panellists, I've got some really exciting legal disclaimer stuff to run through with you all. I promise it won't be too painful. So we're offering today's live stream webinar as a free service to give guidance and support to business owners at this time of great uncertainty. The information we provide is general in nature and cannot replace detailed accounting or legal advice. If you're watching today, you are able to pose questions through the live Q&A function on Zoom, and our panel will do its very best to answer that for you today. So it's important today when you understand, it's important today to understand when you listen to the answers that are given, that those answers will be given to specific questions, often in the absence of all the background facts and documentation that relates, which often can be substantial. And equally, some of today's panelists might talk about proposed legislation, and where they do so, they can only talk to the guidelines that have been made public. And in many cases, we're operating on the same information that's available to everyone else, whilst putting our professional expertise and overlay on that. So you shouldn't rely on the information or answers given today to support an accounting or legal position you may wish to adopt. Rather, today the answers and advice is given to assist with general understanding of the landscape as we understand it here and now today. And in closing, before I hand over, you should always take detailed accounting or legal advice about your specific situation before acting or committing to a particular course of action. Rightio, so that's the necessary disclaimer over and done with. So now I'd like to hand over to the panel to begin today's discussion. In the honour of starting us off, we'll go to Andy. So over to you, Andy.
Thank you, Brad. Over the years, I've seen problems with small to medium enterprises culminate in very stressed company directors arriving on the doorstep here with either a statutory demand in their hot little hand that somebody has served on them in the most gentlemanly or ungentlemanly way possible, or moving on to more serious matters, high court proceedings to wind the company up or place it into liquidation. So in earlier webinars, of course, we discussed how to perhaps avail oneself of the mechanisms that are available within the Companies Act and proposed to come in through amendments to the Companies Act about hibernating debts, about creditors' compromises, and above all the old N word, negotiate, negotiate, negotiate. Sometimes, however, the debt just keeps on coming and it keeps mounting, particularly with debt that comes from IRD, and in particular in that arena, GST and PAYE payments that haven't been made to the revenue, which incur significant penalties and interest that seem to push people one step backwards for every half step forwards when they're trying to get themselves out of the quagmire. We can negotiate settlements with the revenue before it gets to the stage of liquidation proceedings. We can still negotiate with the revenue during liquidation proceedings and hope for a more successful outcome than liquidation. But sometimes the directors and shareholders of companies form the opinion, and usually quite rightly so, that the company is beyond salvaging. It's spinning the little hamster wheel as fast as it can and going absolutely nowhere. And the time has come to draw a line under the affairs of the company. Now, sometimes too, a company may be completely solvent and able to pay its debts and all the rest, but just simply outlived its usefulness. They want to close it down. Commonly held view is that you just do nothing and the company will fall off the company's register, and that's the end of that. You walk away, sail off into the sunset and wave goodbye to everything and everybody. In the case of a solvent liquidation, put the company assets in your pocket and off you go. Unfortunately, that's not the reality of how you kill a company, if I can put it in the colloquial. A company is a separate legal entity and it needs to come to an end just like a human life. That process is liquidation, whether it's a solvent or an insolvent liquidation. A solvent liquidation can be just done by the company itself, signing a resolution to put the company into the hands of a liquidator, and a further joinder that it is solvent and the directors and shareholders believe that at the conclusion of the liquidation, that all creditors will have been satisfied and the company would owe no obligations to anybody, particularly including the revenue. Insolvent liquidations can also go down a two-route track. Either the company can resolve to wind itself up and appoint a liquidator, or you can wait for the inevitable when somebody has served a statutory demand on you and you have either been unable or just don't want to pay the sum demanded, and liquidation proceedings are subsequently served upon you. Then the matter proceeds through the High Court, and the High Court appoints a liquidator. Now, there are significant differences in the outcomes that may be achieved by the appointment of a liquidator, whether internally or by court order. There can be some degree of control already discussed with a liquidator in a company-owned liquidation process. And the liquidator will have a very good handle on what's to happen when the resolution putting the company into liquidation is signed. In the case of a court-ordered one, the company or the company directors and officers have never engaged generally with the liquidator that is appointed by the court, and the petitioning creditor has nominated that liquidator in the hope that the petitioning creditor's best interests will be accommodated rather than anybody else's. To further explain the mechanisms behind the various ways of putting a company into liquidation, I'll hand over to Lynda, who does this on a regular basis. Thanks, Lynda.
Thanks for that, Andy. So as Andy's pointed out, there are two mechanisms that can be used to place the company into liquidation. So the first of those, where it's the directors guided by the shareholders who are deciding that they're going to place the company into liquidation, that's done by way of signing a shareholder resolution. It is a special resolution, so it does need 75% of the shareholders to sign that. So part of that process, obviously, if you're in a company and you own a 50% interest, you need to get agreement from the other shareholder before you can actually place the company into liquidation. If there's a large group of shareholders, again, you've got to get that 75% in number. And it's a fairly straightforward resolution that we would prepare as liquidators and discuss with you and explain what the implications of that are. So that's your shareholder appointment and how it's actually brought into play. Obviously, there's discussions that happen before that. So when we're doing a shareholder appointment, we can actually meet with the shareholders, meet with the directors and the interested parties, and just fully explain that whole process. So I guess what I'd sum it up as is the no surprises option, where we can actually talk to you about the solvency of the company, what its assets are, what the issues might be. Obviously, we don't make conclusive decisions because it's very early in the process, but we can give you some guidance about what to expect once we're appointed. The other option where you're looking through the court appointment, basically everything's taken out of your hands in that pre-appointment phase. So what would happen is, as Andy said, someone will serve you with a statutory demand. A lot of people don't actually seem to realise the implications of that, but it does set the time ticking on when you can then make decisions about your company. So if you can't comply with that statutory demand within 15 working days, and it then becomes an expired statutory demand, that's the basis that the issuer can then use to approach the courts and say, hey, this company's insolvent. I've got proof that it's insolvent. I've got an expired statutory demand. Therefore, I want it to be wound up. So the process for them to do that once that stat demand's expired is that they will approach their own solicitors and they will file an application to the court. At that time, they'll then ask a liquidator's consent to act as the liquidator to the company, should their application be successful. So here at Rodgers Reidy, we take a mix of those appointments. So probably around 50% of our appointments are coming from shareholder appointments, and the other 50% are coming through that court process. And it's really around the information. So as Andy said, in that court process, we're phoning people on the day of appointment from notification with the court and saying to people at that point, look, your company's in liquidation, I've been appointed as the liquidator, and we'll be taking over control and management of the company moving forward. Where it's a shareholder appointment, we will have had meetings beforehand and you'll understand what that process is. We can arrange for the orderly control of assets to be taken over and work through with you, handing over the records and all of those things that we require in the liquidation. The approach tends to be as well that if it's a court appointment, that probably you're not going to be quite as cooperative as you would be in a shareholder appointment. And certainly your creditors would prefer that if you are insolvent, you do a voluntary liquidation and save them the cost of having to apply to the court. So there tends to be a little bit more perhaps aggravation from creditors in those court appointments than what you may get in a shareholder appointment. The other downfall with the court appointment, of course, is you've still got to sit there in place as the director while all of this process is going on. So whilst you're fending off those stat demands, you're waiting for the court date, you're then having to deal with all the other company creditors as well. So we deal with a lot of people and they're coming to us at the point that they're just exhausted from the phone calls, the emails, the people wanting payment. They don't know what to say, they're not sure what to do. And when people are at that stage, you know, and normally that happens well before the stat demand, but that's the time to come and talk to your professional advisors, whether it's your solicitor, your accountant, or an insolvency professional. And coming to us at that early stage, we can look at some options, and it may be that there is some option to salvage an element of the business, if not the whole business. So that's why we really encourage that early contact. And you know, we're happy to have a free discussion with people who are in that situation and want to look at what options might be available to them. The other thing, just while we're here, just to talk really briefly on directors' duties. There's been quite a bit of talk around the government relaxing some of those duties around reckless trading, and in particular around Section 135. And I just think it's important for people to understand that that's not a license to just go and run the company however you want. It's very prescribed, and it does talk about that you must have been able to pay your bills as they fell due as at the 31st of December. So if you think of it in your normal pay run, normally on the 20th of December, you'd be paying all of your November creditors. If for any reason you weren't able to do that, then that criteria probably won't apply to you, because a creditor would be able to come forward to the liquidator potentially later down the line and say, well, look, I know that they couldn't pay their debts as they fell due as at 31st of December. Here's my overdue account that was meant to be paid. So what we're seeing at the moment is a lot of companies that were a little behind in payments, but were planning that they were going to be able to trade out of those based on future income. And what's happened as a result of COVID-19 is that a lot of projected income has disappeared, contracts have been cancelled. So those ones that in the normal way of things may not have had to liquidate, they're now having to look pretty realistically at, well, can I actually trade out of this? And you know, we'd say to anyone that is facing issues with their creditors that you really do need to seek advice around what's the best option for you. There are a few different options around, and there have been some new packages put out by the government. However, it's really important that you make informed decisions about what you want to do with those. So that covers off really, you know, liquidation really briefly. Look, I'm happy to talk to anyone else who's got more queries around the process beyond the appointment process and what happens, and talk around what your particular issues might be in your businesses. But for now, I'll hand back to Brad.
Right, thank you very much, Lynda. That was that's some really good stuff in there and outlining the process involved with liquidations. And I think one of the things that we see a lot of, or I know Andy sees a lot of, is the Section 289 notice that goes unheeded and ignored, and you really ignore those at your peril. So if you're getting in a tight spot and you're starting to get these sorts of notices served on you, I can't stress enough how important it is to take early advice from your accountant and your lawyer before you get yourself into an irretrievable position. Andy, is there anything you'd like to add at this stage to what either you've said earlier or Lynda's just talked on?
Sorry, just a minor technical glitch there. Couldn't unmute myself, which is strange for a lawyer. Being mute, it's not good. Not a good look. Not a good look at all. Brad, and Lynda, there's once the company's put into liquidation and the liquidator has realised all the immediately available assets, what happens after that? What do you do? Because we've still got this entity, this entity, but albeit that it's in liquidation, that we still have this separate legal entity floating around, which may still be owed some money, or may owe, well, it did owe money, and there may be a class of debt that may still be owed. What happens, Lynda, if you could explain that process a little?
Yeah, sure. So the primary role of the liquidator is to act on behalf of the creditors and to realise the assets of the company for the benefit of the creditors. So a lot of those assets are immediately identifiable and things that people understand quite easily. Could be plant and machinery, it could be vehicles. Those are the easy ones to deal with. They get picked up and they get taken off to auction. The other things that we will deal with as well, though, are the collection of the company debtors, realising any work in progress and maximising recoveries on those. On construction companies, we'll work through on recovery of retentions. We'd realise non-financial or non-tangible assets, so things like investments in other subsidiaries or in listed companies. We sometimes have to deal with those as well. So we go through all of those and realising the assets. We then also have to look at what further recoveries may be available for the company on behalf of the creditors. And that's things like looking at voidable payments, where perhaps one party's been paid sums prior to liquidation, but they've ended up in a better position than what all the other creditors have. So we need to have a look through what payments were going out and what transactions were entered into. We look at any assets that have been sold prior to liquidation to determine if they were paid for full value or not. And then we also look at, are there recoveries against the directors? And this is around these issues of reckless trading or incurring obligations when they knew they couldn't realistically pay for them. So that's an element of what we do as well. If a director's got a current account with the company, and this is something that a lot of people don't understand when they look at their financial statements, is what their current accounts actually are. And it's like the running account of the loan between the company as a separate legal entity and the shareholders or directors as individuals. So we have to have a look at that and work out if we need to make any recoveries on that as well. So those are generally the processes. And at the end of it, we end up with a pool of funds. And we also have a pool of creditors, and then we use the 7th schedule of the Companies Act that specifies who should get paid out of what pool of funds and in what order they get paid. So employees are up near the top, obviously. They're called preferential creditors. So's inland revenue for any GST and PAYE. A lot of your trade creditors, unfortunately, come down in that lower level of unsecured creditors. But some people can have protected their interests a little better, and we deal with secured creditors as well. So there are ways well prior to entering into any of this that people can protect their interests. So at the end of all that, and we've paid out the funds and cleared out any recoveries that we've made, At that point, we then write a final report, which gets lodged with Companies Office, and we apply to have the company struck off at that point. So there's an objection period, and then basically it is the death of the company, for want of a better word, and liquidators are sometimes referred to as the corporate undertakers, because that's what we do. We basically bring the companies to an end, and that's the final element of the work that we do. So that's how it finally gets removed from that company's register.
Thanks, Lynda. One of the things that quite often vex my clients who've been chased by a liquidator is, oh, the car that I'm driving, it's actually mine, but I just put it in the company's name because it was easy, you know, to get some write-offs and some tax relief and get my fuel paid and things. What happens in that situation, Lynda?
You think that is really common, and a lot of people, when they're making those decisions to put assets onto the company books, whether it's a vehicle or a computer or whatever that asset might be, they're not really thinking through the long-term consequences, that the company is a separate legal entity to themselves, and that by putting it in the company name, they're then putting the ownership into the company. And in that situation then, as liquidators, we would be saying, look, we need to realise that asset. Sometimes it can be that the director wants to purchase it back from the company, and as long as that's done at fair value, that's something that can occur, and that can be done as part of the liquidation process as well. It is interesting though how many people do that, and also how many people don't understand the difference between the NZTA records and legal ownership. So the name that something's registered on the NZTA isn't necessarily who the legal owner is of the vehicle. So that's another thing that sometimes trips people up.
Thanks, Lynda and Andy. I'm just going to jump in there because questions come through in the Q&A that would be good, I think, to pose at this stage and break with tradition. So I'll just read that out. Go to my other unmute. Rightio. So the question that's come through is, what range of costs do businesses generally see from liquidators? So what does it cost, I guess? And is this recovered from the assets ahead of other creditors? So I guess it's a question, Lynda, of who pays the liquidator and how does that happen from where?
Sure. So when we talked previously about that order of who gets paid and how employees are preferential, the Companies Act does provide that the liquidator actually gets paid first for any costs of the liquidation, which includes the liquidator's time, but also disbursements of costs of advertising liquidation and things like that that we have statutory obligations to do. So the costs of liquidation do come out first. They generally come out of the assets of the company. So once we've realised the assets and we go through that payment schedule of the order of payment, the cost of the liquidation come out, then you start to work through the preferential and unsecured creditors. Cost is a really difficult thing to know because it depends very much on the size of the business that we're liquidating. So in a similar way, someone might say a generic question of what is the cost to buy a business? Obviously, it depends on the business that you're purchasing. When you talk about what's the cost to liquidate a company, it depends on the cost of the company that's being liquidated and how much time is going to be needed from the liquidator to realise those assets. And that's something that we would discuss with people at the outset once we actually know what those assets are. It's fully disclosed in the liquidators reports, what fees have been taken, and also under the Rattan's Code of Conduct, there's certain things that need to be adhered to by the liquidators around their fees and their rates.
Excellent. Thank you very much, Lynda. Look, thank you, Lynda and Andy. Just in the interest of time, we might move on to James, who's going to speak to us next. But if you have any questions that you'd like to ask either Andy or Lynda on the subject of liquidations, then feel free to send your questions through on the live Q&A, and we'll come back to those at the end of the session. So thank you, Andy and Lynda. And James, I'll hand over to you. Thank you.
Thanks, Brad. So last week I was talking to you all about the bill that was moving through the House there was putting in place some of these safe harbour and business debt hibernation schemes, just considering businesses who are struggling to manage their cash flow at the moment and what options might be there for them. And I just want to tie this in with what Lynda was saying before about the fact that a lot of these new measures are very prescriptive. The thing I mentioned last week that I want to remind everybody about is that you will be required to prove your actions were in accordance with those prescriptions if you need to rely on the protections later. So every decision you're making that is important or serious, or that might be questioned in a liquidation, for instance, you need to keep some good evidence of what you're doing, record the reasoning behind the decisions and any supporting calculations or forecasts. Just keep that stuff handy, you may need it. So we were looking at the differences between perhaps the normal sort of composition or compromise of debt with creditors and then the new business debt hibernation scheme. And one thing that I've noticed that I just wanted to mention, because I think it's quite important, is that the protections of business debt hibernation will not apply to creditors that have security over substantially all of the company assets. Now, I'm sure that many of you who are business owners have signed up for trade accounts with suppliers, and it's very common for those standard form terms and conditions to have what's called a GSA, or a General Security Agreement. So it seems to me on my reading of the new schedule that may mean that if you choose the business debt hibernation option as opposed to a standard form composition, that those creditors that have general security agreements may not be required to follow that limitation on their rights, and they may actually still be able to proceed and seek a liquidation or a recovery of those assets. So you'll need to take advice if you are considering this business debt hibernation scheme. That wraps up the talk on that Companies Act amendment stuff. Well, lastly, I'll just point out it's at the stage of royal assent now, so it's had all of its readings in the House, but it doesn't seem to yet be formal legislation, but obviously that's imminent. I've been taking a look at this new small business cash flow loan scheme over the last couple of days, and I'll start by saying it's diametrically opposed to the business debt hibernation scheme. Don't think that you can use both, because one critical term in the contract for the small business cash flow loan scheme is that if you enter into a composition with your creditors, a general assignment for the benefit of your creditors, or any sort of moratorium on debt, that you will then be in default of the business cash flow loan scheme, and that causes an immediate acceleration of the due date. So the two are just incompatible. Don't be going for both. Go for one or the other. Make some hard decisions. Get some professional advice about which way to go if you need to explore these things, but don't think you can do both. With the small business cash flow loan scheme, there's been a lot of publicity about it being interest-free. So that is true if you repay it within 12 months. Should you not repay it within 12 months, then it's interest-bearing, and it's interest-bearing from the very first day that you receive the loan. So you don't get a 12-month interest-free and then the interest starts. So bear that in mind. The interest rate is pretty low. It's mortgage rate really at 3%. So it is cheap money if you do need some funding. The only other fish hooks in it is that it's linked in with the wage subsidy scheme quite tightly. So if it's found that you made an untruthful disclosure or a statement in the application, either for the small business cash flow loan or for the wage subsidy, or if something later turns out to be untrue. So at the time you made the declaration, it was fine, but then things changed and for some reason you weren't entitled to it because perhaps you didn't actually suffer a 30% drop in revenue, for instance. Well, a default of one or the other will trigger this acceleration of the repayment of the cash flow loan scheme. So you really need to be aware that they are linked together. The other thing is if you are currently structuring things with a view to winding up your business or to closing down your operation, well, then that also is another ground for the loan not to be available to you and for it to be accelerated. So only apply for it if you are going to carry on in business. Then if there's a substantial change of the nature of the assets, for instance, if you sell your business or if you look to transfer the assets to another company, it's triggers like that which will make the loan immediately due accelerated up. So if you do sell your business in 6 months, well then at that time you'll be required to repay that loan. Likewise, if you were simply to restructure your affairs and move your assets or the intangible business asset out of that company, that would also be a trigger. I think that's probably all I wanted to say. Yes, that's my list. So if you've got any questions and answers, then please by all means go about asking them, and I'll hand back to you now, Brad.
Awesome. Thank you, James. There's some really good information in there and some clear distinctions to be drawn for business owners looking at either one of those two options. So need to be careful there, and I'd suggest take advice, detailed advice on those options. Rightio, so that brings me to the piece that I want to speak about today, which is businesses obviously finally moving through into level 2 today, or many haven't previously been open. So I want to talk today about the issue that some business owners may face about staff who refuse to return to work in level 2. And by now, some of those issues may have already come out or may come out in the coming days and weeks, depending on how things play out with the relaxed restrictions. And of course, to be operating at this point in time in level 3, businesses should have already created a COVID-19 safety plan in order to comply with the public health guidance and the overarching legislation. If you haven't already done this, then you need to get going. You're behind the 8 ball, and there's some really good online resource on the WorkSafe website, which is worksafe.govt.nz. So check that out if you need to. You can also check what you've done against that. So what do you do if you've got an employee who refuses to return to work? Can they refuse to return to work if you've taken appropriate health and safety steps? Generally, the answer is no. And I say generally because, as with all things in the law and employment law as well, there are caveats and exceptions. So generally the answer is no, an employee cannot refuse to return to work, but they may refuse to come to work where an employer has failed to meet the obligations that are owed to that employee. And the obligations we're talking about here principally are the obligations owed under the Health and Safety at Work Act 2015. And that Act imposes a number of legal obligations on employers known under the Act as PCBUs, which is a person conducting a business or an undertaking. So the primary duty of care that an employer owes, and it's very broad and overarching, and is so far as reasonably practicable, is to provide and maintain a work environment that is without risk to health and safety. And that includes provision of information, training, instruction, and supervision that's necessary to protect people from risks to health and safety arising from the work they might carry out. And an employer must ensure that the health of workers and the conditions in the workplace are monitored to prevent illness or injury to workers arising from the work they do. So we don't have time today to go into a detailed analysis of the Act, but the obligations and duties imposed are extensive. But these duties, as with many duties in employment law, flow two ways. So that means that your employees also have duties as well under the Act. So they're required to take reasonable care of their own health and safety and reasonable care of the health and safety of others in the workplace to ensure they're not harmed by something they do or don't do. They've also got to follow any reasonable health and safety instructions that an employer may give to them, so far as they're reasonably able to. And they must also cooperate, luckily, with any reasonable business policy or procedure relating to the workplace's health and safety that they've been told about by their employer. However, under this Act, employees have the right to stop work if they believe it's unhealthy or unsafe, and that extends to refusing coming back to work if they believe the workplace is unsafe. So if they think there's a risk of coming back into the workplace on level 2, due to fears over COVID-19, you should attempt to understand and address relevant concerns. There are a number of grounds where employees could at the moment legitimately refuse to return to work. So, for example, they can refuse to return to work where public health guidance is that they stay at home. And this encompasses a number of different people, groups of people. So, of course, firstly and foremost, the employees who might have COVID-19 and they're sick with it. Those employees who are required to self-isolate because they've come into close contact with someone who has been infected with COVID-19. Those employees who may have dependents that are either infected or come into close contact with someone with COVID-19, or the category of employees who are at higher risk of becoming severely ill with COVID-19, or have a person in their household that is at a higher risk. And we've actually seen a couple of practical examples of this, and we've discussed these in the last couple of webinars. Specifically an example where someone had a person in their bubble in their household who was at a higher risk of contracting COVID-19 due to being elderly. And then, of course, you've got employees with pre-existing health conditions, or those who may be immunocompromised. So there is a number of different people there, you can see hopefully from those categories, who might have a legitimate reason to refuse to return to work. Now, if you've got an employee who might fall into one of those categories, there is another form of leave entitlement that applies to them and that you may be able to apply for on their behalf via the government. And that's the currently that's the leave support scheme. So there is some wage subsidy assistance available there for people in those categories. So there are some people that can refuse to return to work, as we've just discussed, but if those circumstances don't apply and you have an employee who is refusing to come back to work, what do you do? Well, first of all, as we've stressed across this webinar series and whenever we've been talking about employment law issues, is that you must consult in good faith. And what I mean by that is you've got to find out why they're refusing. What is the basis that they're hinging this refusal on? So in terms of some practical steps you could look to take to address this sort of scenario if you're confronted with it, is you need firstly to ask your employees for their feedback on the existing proposed health and safety measures for COVID-19 that you've put in place for your workplace and work environment. And you also need to be asking employees to communicate with you if they are at risk of having contracted COVID-19. And then going back to this consultation piece, you're going to need to be speaking to them and teasing out why is it they're refusing to return to work. What is the basis for that? What are their concerns? Now, that's okay, and we often get asked these sorts of questions. How do we do that? Is it okay to do that sort of consultation over the phone or via email or via Zoom? Of course it is. That's absolutely fine. The important thing is that you attempt to understand why the employee is refusing to return. So you should really try and get as much detail as you can from the employee about their refusal and what concerns they have and what the issues are for them. And then you need to go away and think about what they've told you and subject that information to a careful objective assessment. Don't knee-jerk and react emotionally because no doubt this will be frustrating, but you need to think about it carefully before you form a predetermined view as to the reasonableness or otherwise of the position that they are adopting. The reality is that the nature of the COVID-19 pandemic has left many people with uncertainty and fear, in fact, and your employees may justifiably be feeling stressed and anxious about contracting COVID-19 or risk of being exposed to contracting it. So if that's the case for the employees you're talking to who might be refusing to return to work, you should consider practical ways you could look to address those concerns, such as offering flexible hours, ongoing remote working where that's practical or possible, or housing those employees where possible, once again, in several areas of the workplace away from your other staff. You could also look to discuss alternatives, such as taking a period of annual leave until COVID cases reduce further, and I see today we're the third day of no new cases, which is fantastic. Or you could ask your employee to seek medical advice and, if required, obtain a medical certificate to remain at home due to stress and anxiety. and or take a period of sick leave. So I recommend you get some advice around those different options if that's what you're looking at, so you don't fall foul of any traps that can be inherent there. But there are a number of different alternatives you can pursue. If you've got a situation, however, where your employee is saying, look, the workplace simply isn't safe for me to return, and if there is some validity to those concerns, then you definitely should be attempting to alter the employee's working arrangements to ensure that they're as safe as reasonably practical. And ideally, if you've already, up to this point, consulted with your staff on the implementation of a safety plan, these issues should have already been addressed. There may, of course, simply be a category of employees who have enjoyed working from home a lot or too much, and may wish to request more flexibility in how they work in the future. That should be addressed, of course, in good faith, but ultimately when it's safe to do so, and you are, accepting the exceptions I've outlined, entitled to ask your employees to return to work to their previous working practices. There are flexible working arrangement provisions of the Employment Relations Act where employees can make requests for flexible working arrangements, and there are some rules in the Act around those sorts of requests. So if you need help with those in future, then get in contact with us. However, if you've gone through these steps and you've sort of reached a dead end, and I've already spoken to a few people where this has been the case, and especially if the refusal to return to work is not based on any reasonable grounds, then this may give rise to a disciplinary issue, sadly. If disciplinary action is warranted, you should follow ordinary processes for handling misconduct, again in good faith, and most critically in adherence to the contractual requirements under your employee's employment agreement. This is often an area where many employers slip up and get it badly wrong. So the first step is always to consult the written terms of your employee's employment agreement to understand whether this sort of refusal, the refusal to return to work, is recorded as a class of misconduct under the agreement, and what disciplinary process, if any, needs to be followed to address the matter. I think it's really important for you to be aware in this environment that any disciplinary action you may want to take where an employee refuses to return to work should be very carefully thought through. I say that because there are heightened emotions and fears at this time, and this sort of action could blow the lid off a pressure cooker and blow up in your face very quickly, and could result in lawyers' letters, heaven forbid, flying left, right and centre. So I'd recommend you take detailed advice from an employment law specialist if you're looking at going down that path. I wouldn't do that lightly. Of course, an employee's refusal to work, let's be honest, can be extremely frustrating for business owners who many are fighting simply for survival at this point in time and just simply want to get going. It's the last thing you want to be dealing with. So in my experience, many employers wish to turn these sorts of refusals into a disciplinary matter for failure to follow a lawful and reasonable instruction. And that type of immediate, what I term knee-jerk response is, in my view, with respect, the wrong one, because you must consult with your employees in this situation to understand their concerns, and whether your instruction for them to return to work is lawful and reasonable will really turn on the preparatory planning you've done, including the implementation of an appropriate safety plan that you've communicated to your staff and had their feedback on. So although the issue can be frustrating, there are several different ways in which resolution can be achieved and accommodations can be reached. The key with all employment relationship problems is to communicate openly and honestly in good faith and not adopt fixed, irretractable positions from the outset. So see this as an understanding to deepen, as an opportunity to deepen your understanding of your employees and what is important to them. Perception is a very powerful thing, and what they are perceiving may well be different from what you're perceiving, and communication therefore becomes critical. The reality is that COVID-19 has caused widespread fear and anxiety for many people about their health and safety and the health of their loved ones. We all have a duty to work together to ensure any risks to health and safety in the workplace are managed sensitively and appropriately. So I'll close off my piece there, thank you. So what I'm going to do now is throw it open to the panel for Oh, sorry, Andy. I muted myself. So I'll close off there. What I'm going to do now is throw it open to the panel for the Q&A. And we've had a question come through in the live Q&A. So this is a question for you, James. James, can you use the government loan to buy assets?
The short answer is no. The loan has a declaration which says that you will use it for core business expenses, and then there's some examples such as rent and insurance. So core business costs, think of it, this money's not for capital type of expenditure, it's not for loan reductions, it's not for buying big assets, it's for keeping the business going and paying normal expenses. Now, having said that, if by asset you mean buying a power drill to complete your work, that would probably be fine. So small assets that are required for you to complete your work could, in my opinion, be viewed as core costs, but large plant and equipment or cars, no, I don't think that would be acceptable based on the wording. That's my answer there, Brad.
Thank you, James. Rightio. Okay, so we had a couple of questions come in before today's webinar, so I'm just going to pull those up. Rightio. So this question that I've got here, rightio. I need to close my business down. My accountant said that I need to put it into liquidation to close it down. My accountant has also said that she could not act as the liquidator as she currently acts for the company and debtors involved. So what's the answer there? Any thoughts, Lynda?
Yeah, so your accountant's correct. They're not able to act as liquidator on an insolvent liquidation. There's requirements that need to be met that you haven't had a previous association with the company to be able to act on an insolvent liquidation. It's not the case for a solvent. Your normal accountant, if they're experienced and they're comfortable doing solvent liquidations, may be able to offer that service to you. Where it's an insolvent situation and there's creditors involved, then there needs to be someone new and independent who can then act for the creditors' interests. So that's where you'd need to go to someone outside of the firm. Look, our recommendation would be that you go to an accredited insolvency practitioner to give yourself some assurance that you are dealing with someone who's experienced and knows what they're doing as well.
Great, thank you, Lynda. Rightio. Okay. So this next question here, the IRD are hounding me over unpaid GST and PAYE. They sure will do that. I had to use the money set aside for those payments to pay wages some 18 months ago and have never caught up. The debt keeps climbing because of IRD penalties and interest, and now they have started proceedings to wind up the company. Will the debt to IRD form part of the debt and be extinguished when the liquidation has finished? Anyone want to tackle that one?
I'll jump on that if you like. Andy, if you've got anything you want to add when I'm finished, feel free to. So, look, the difficulty is that at the time that you make the decision not to pay IRD, you've then at that point actually chosen to prefer one creditor being your staff member over paying your IRD debt. So at that point, it shows that you've got a difficulty in being able to pay your bills as they fall due. What's happened then is that's been exasperated over time, and you are running the risk that you're trading whilst insolvent because you haven't been able to catch up that debt, and now you're probably making decisions on a month-by-month basis as to do you pay the IRD debt or do you pay someone else. Those penalties and interest, they do climb really high. The IRD is one of the most expensive financiers you could possibly use for your business, and yet it's often the course that people take that they choose to use that money and face those penalties and interest. So if it's got to the point that they're now threatening to wind you up, I'm assuming you've already tried things like putting into place payment plans and that those haven't been able to be met. And you're now at the point really that I would say it's inevitable that the company be liquidated. You can still do a voluntary liquidation and have a chat with a practitioner around the liquidation process before it actually gets to the court. But yeah, obviously you need to have exhausted all of those opportunities to have the discussion with the revenue and see whether you can come to some sort of payment arrangement.
Just adding on to that, if I may, Lynda, I recall the question as specific about GST and PAYE. Now, my understanding, and correct me if I'm wrong, is that the revenue treat those funds as trust money. You've collected PAYE out of your employees' pay to hold in trust to pass on to the Inland Revenue Department. The same with GST. You've collected GST off customers to forward to the revenue, offset of course by any claims that you have for GST that you have paid. So I understand that the revenue can on occasion follow through, lift the corporate veil, but follow through and make the director personally liable for that GST and PAYE debt. Have you come across circumstances like that, Lynda?
Yeah, I have. It's not an automatic that the person becomes personally liable. What tends to happen in that scenario is that the liquidator will take the approach that you've traded recklessly as a director by allowing that debt to accrue and by preferring other creditors who aren't preferential. Just bearing in mind that GST and PAYE are preferential debts and they therefore rank ahead of other creditors. So in choosing to pay other creditors in preference to the IRD and continuing to do that over time, that becomes an issue of reckless trading. And it's that would then lead to the director potentially being personally liable for those debts. The other thing to throw in the mix too with PAYE debt is, with that being quite clearly trust monies, that at the time you pay your staff the net amount, you're really signalling to them, look, I owe you $1,000 for wages, I'll pay you $800, therefore it's implied that you're holding the other $200 and that you're holding that on trust to pay to the Inland Revenue on their behalf. So there can be circumstances where the Inland Revenue can also look at criminal action around the non-payment of PAYE debt. And they've got their own risk criteria that they follow in choosing which cases they think they want to prosecute versus which they don't. So it's something that you need to be very mindful of. And one of the things that we discuss at people at our first consultation meeting is, who is your debt with? And if it's with IRD, what is the split between PAYE and other debt types? So it's not the payment to choose not to make, it's the one that actually should be being paid first before other creditors. And unfortunately, some people, because the other creditors are on the phone all the time, they're making those decisions on the spot without actually thinking through the consequences of them. So you're quite right, there can be that issue with it being the trust monies and can lead to some personal liability or possibly criminal action.
Great, thank you, Lynda. We've just got time for one more question today, and James, I don't want you to feel left out in the cold. So it's actually a question that came through a couple of days ago, and we're jumping back to wage subsidies. James is also an employment law practitioner like Andy is, and myself. So this is one of those wonderful wage subsidy queries, James. So this question is, a number of employees have received notice this week with their employers using using the final 4 weeks of the wage subsidy to make up their redundancy payout. Given that the wage subsidy is meant to be for wages only, is this legal? Or to put it another way, can a business owner use a taxpayer-funded bailout intended to help save people's jobs to pay them out before they leave? If an employee finds themselves in this position, what can they do?
Thanks, Brad. This is not a straightforward question to answer anymore. At the time people made the application for the wage subsidy, there were 2 different declarations. We've traversed this in previous webinars. If you were part of the later declaration, which is an application after 27th of March, you made a positive declaration that you would keep these people employed and use your best endeavours to do so. So there's a sort of slight inconsistency with getting to the end and dumping people. However, if the economic reality is that you can't afford to keep them on, then you probably have little choice but to start a redundancy process. Just by way of comment on that, if you do find yourself in that situation, particularly as perhaps a hospitality operator, maybe a bar, today there's been an announcement that the subsidy will be available for a further 8 weeks. So you may be able to avoid this or stop the process if you're working through it. The wage subsidy is for that. It's for wages. It's not for paying out notice periods, especially if you're going to pay it out in lieu of notice. However, if you were giving notice and the people were working through that notice period and being paid their ordinary wages for the work they've done, then there's probably no real problem with that. I don't think you'd find it being reclawed. So it will be fact dependent on your circumstances. It is definitely better, I think, for everybody if people are going to lose their jobs to work out their notice if you're going to be applying the wage subsidy to that payment.
Great, thank you, James. Yeah, look, I'd just add the follow-up point there that it's fairly rare, but you do see it sometimes in some employment agreements that there is a redundancy compensation payable as well to employers. Now, redundancy compensation in New Zealand is only payable if contractually negotiated for. So if you were wanting to use the wage subsidy to pay out the compensation, redundancy compensation component, that is a definite no-no, just to be clear. And insofar, if you have any concerns about what the employer is doing, then you can register a complaint via the employment.govt.nz website if you have concerns about impropriety or incorrect application of the wage subsidy. So there is a step you can take there if there's some real serious concerns. Rightio, so toggle between my spacebar and the button. So look, we'll look to wrap things up there for today's webinar. So I would like to firstly thank all the panelists for taking part in today's webinar. It's been fantastic to have you on board with us today, Lynda. So thank you very much for your insights and expertise. Thank you once again, Andy and James. You've been involved in a number of these webinars now, so it's becoming old hat. So great to have you on board again. Thank you. And if you'd like to get in contact with any of today's panelists for a chat, by all means feel free to do so. And at the end of today's webinar, I'm going to share my screen and put up contact details for panelists. Sorry. So stay on the feed to catch that detail. If you have any requests for any particular topics that are of interest to you moving forward, then please feel free to send me an email with your suggestions. But today's webinar will be our last for a while. Moving ahead for level 2 and beyond, we're going to adapt and evolve this webinar series into a podcast series called the Godfreys Law Real Solutions Business Podcast. So that means you'll be able to tune in at a time you're choosing to hear what we in our network of trusted professionals have to say about a myriad of topics relevant to business owners. So stay tuned for your invite to our new podcast. We'll push that out once we've got together, and that's coming soon. So look, it's been a real honour to host this series of webinars. I've been involved in most of them. We've done about 10 or 12 of them. I think the first one happened on Wednesday of lockdown, the day we went into lockdown from memory. So we've done a few, we've got a few under our belt, and it's been fantastic to be able to put these together and put these out to you, our valued clients and attendees. We hope you found some value from the webinars, and we of course wish you all the very best for your businesses and moving forward into level 2 and beyond, and I hope that goes successfully for all of you. And of course, don't hesitate to take professional advice if you are looking at wrapping up your business operations, or you've got some hard decisions to make. There is support out there available for you, and you know, we're here, and the likes of Lynda and Dorian and his firm, who's been involved previously, So a number of trusted advisors that we can put you in touch with. So feel free to get in touch. Sometimes the hardest step is the first one, but don't delay if you need to. So look, from me and the team, thank you very much. It's been wonderful having you on board today. So I will sign out and share the contact details for our team today, and I wish you all the very best. Stay safe and keep well. Thank you, everyone.